basically, I'm a victim of fire and rehire by one company in the UK. And I actually took the stage of not signing a settlement agreement, and I've taken the matter to court. And all along, and I'm not the only person that this has happened to within the company. So all along, I did everything separately. I approached ACAS separately. I did everything separately. However, the Employment Tribunal has actually grouped me with the rest of the colleagues that were sacked who are represented by the same lawyer.
Do you have a problem with that?
Yes.
Why?
Because they're doing it with a system of lead claimants, and I'm not getting the opportunity to basically put my points across personally. And I'm going to be hanging off someone else's, you know what I mean?
Yeah. So I'm assuming the lead claimant is represented by a big solicitor's firm, probably with a QC or a leading barrister representing them.
All of us are with the same solicitor firm.
Oh, so you're all represented by the same firm?
Yes.
Well, I would expect then, Robin, for the cases to be heard together, and that would be totally normal. And indeed, it'd be wrong for it to be done any other way, because courts have limited time available. People have to wait 12, 18 months for a court date. They can't have a 5-day hearing or however long it is for each of the dozens of you. They're all heard together to save court time. And it's also completely normal, Robin, and I'm just saying this to reassure you, for 2 or 3 of the cases to be picked as lead cases. And the reason for that is because, let's imagine there are 30 of you. I'm making that number, I know. But let's say there were 30 people who've brought tribunal claims for unfair dismissal arising from fire and rehire. It would be a waste of time in the nicest way if the tribunal had to hear from all 30 of you and hear identical evidence. Hello, I'm Robin. I swear to tell the truth, the whole truth, and nothing but the truth. This is what happened to me. And then you get cross-examined on it for half a day. And then the next person has exactly the same. And the next person has exactly the same. It just makes sense from a case management point of view to have a couple of lead claimants. And then, unless there's a good reason otherwise, and you can always argue otherwise, the other 28 of 30 cases will pass or fail, will win or lose, based on the first 2 cases. And what normally happens then, Robin, after win or lose has been decided, is that you'll all be dealt with, the how much question, how much money you get, will be dealt with separately. And at that point, you will get your own say, and you will get the chance to tell the tribunal about what money you've lost, what attempts you've made to find a new job, etc.
So there's no way of me actually being able to separate myself if I change lawyers and being dealt with separately?
It's not impossible, but it's very, very difficult, because a tribunal is likely to say, well, there's no good reason for it. I mean, what is your reason, Robin? Why do you think you shouldn't be dealt with at the same time?
To be honest with you, my case is to do with, I was actually sacked while I was on long-term sick. And I wasn't even told about being sacked. I only found out because I had my access to my emails cancelled. So,
but why does that make the fire and rehire aspect different?
It doesn't. It's just my case is, in my view, and in the view of other people that I've checked with, much stronger than the lead claimants that have been selected.
Oh, well, that's interesting. But they're probably additional grounds for unfair dismissal rather than different fire and rehire grounds. It does sound to me like it might be worth writing to the tribunal and asking them for your case to be heard separately or listed as a lead claimant. But you will need to get the lawyers to agree to that or get other lawyers. And I don't think it's going to be easy. Most tribunals would be reluctant because everyone thinks their own case is a bit different. Everyone thinks their own case is a bit special. And I'm not saying yours isn't, but it's not always easy to persuade a tribunal of that. But Robin, good luck. What it will need is an application to the tribunal, and this is just done by letter, to have your case heard separately or have yourself joined as a lead claimant.